Here.
Judge, that's Nate.
There should be a button at the bottom left to enable video. I can hear somebody on an iPhone, but I don't see anybody.
That's Nathan Richards, Your Honor.
Yes, it's Nathan Richards. I don't see anything on the bottom left of my screen, though.
If you put your finger down at the bottom left-hand side and see if some icons come up.
Let me pull over. I'm driving right now. Okay.
Yeah, not smart.
No. Well, I was headed down to Beaumont. Let's see. Okay.
Gotcha.
There you are.
Yes, sir. All right, so we're here on the estate of Martha Richards Ballard, and we've got Mr. Dowden's motion for withdrawal of counsel. And I'm not
Yes,
sure I understand this, Mr. Dowden. It says that you are the attorney of record in the estate of Lois Odell Dyer, and that a dispute has arisen between the estates, I guess, of Ms. Dyer and Ms.
Got them both today.
Okay, so we have them both today.
Yes, sir. That's correct.
Okay, why don't you go ahead and try to explain to me what's going on, Mr. Dowden?
Yes, sir. Your Honor, in the estate of Lois Odell Dyer, I am the attorney of record, known as Dyer since, I don't know, I was 10 years old, maybe longer than that. So I represented Mr. Richards. Nathan Richards is the executor of that estate. We handle that estate. Inventory's been approved. Subsequently, one of the beneficiaries was Martha Richards Ballard, who is Ms. Dyer's daughter, one of her 3 children, along with Nathan Richards, who's with us, and David Richards, who's represented by Mr. Rick Williams, I understand. And so, as I understand,
Williams going to be on here today?
well, I'm sorry. I don't know, Judge, but we have a green card where we notified David of the hearing.
Okay,
And,
Mr. Williams is not out in the audience?
Yes, sir.
Okay, he's not out there in video land, so go ahead, Mr. Dowden.
So Mr. Richards contacted Mr. Williams, who sent a request for an accounting to Nathan Richards on behalf of, I think on his personally, on his behalf, on David Richards's behalf. David is the executor of the estate of Martha Richards. Nathan's the executor of the estate of Lois Dyer. And I'm the attorney for both estates. And there's a conflict that may have developed. And I understand Mr. Williams sent a letter to Mr. Richards, Nathan Richards here, asking for an accounting. So at Nathan's request, a couple of weeks ago, we delivered a copy of the will, which includes the trust, over to Brandon Monk's office. And I spoke with him just now, Judge, prior to logging on, and he tells me that he anticipates he's going to be retained by Mr. Richards to represent him, but he's not officially retained at this point in time. And Nathan, you could speak to that.
Yes,
Nathan?
I thought he was retained, but I'm headed to his office right now to give him all the pertinent paperwork that I have.
Okay, Mr. Richards, so you don't have any objection to Mr. Dowden's withdrawal motion in this case, is that correct?
That's correct, Judge. I understand his point.
Okay, and that's in the Ballard.
No, sir, that's Dyer, Judge. Nathan is the executor of the Dyer estate.
Okay, so in the Ballard case, you're also seeking to withdraw, and you were attorney for David in that case, is that correct?
Yes, sir. That's correct.
And so what's going to happen with that case?
Well, I expect that, I think there's a hearing scheduled, Judge, with you on the 30th or the 31st on the Rick Williams's request for an accounting from Nathan. I expect that I'll get a motion to substitute Rick Williams for myself. I'm not really sure why I haven't received it by now.
Sounds good. Is there anything else that you'd like to say, Mr. Richards?
No, Judge, there's not.
All right. Well, I hope y'all have a great week. Let me know if y'all need anything else, and we'll see y'all on the 30th.
Thank you, Judge.
Take care.
Thank you
Yes,
too,
sir.
Larry. Thank you
Thank
too,
you,
Larry.
Nathan. Have a safe trip.
You bet. You too, bet. Thank you.
So, Mr. Biggers. I don't see Wyatt.
He withdrew on the 9th.
That's right. Ready for Mr. Biggers?
It's been a long time since I've read this thing. Yeah, okay, I remember it. Okay, bring on Mr. Biggers.
There wasn't anything order or anything like that.
No order on the motion summary
No,
judgment.
sir.
Good morning.
Morning, Your Honor. How are you?
I am doing well. So Mr. Snyder withdrew last week, I believe,
Yes, sir.
and you have a motion for summary judgment. Why don't you go ahead? It's been a while since I've read it. Why don't you go ahead and summarize that for me?
Sure, perfect. So as you know, we represent the plaintiff, Lori Harwood, and her two children. The decedent, Raymond Earl Harwood, died in January 31st of 2014. He left a will with the beneficiaries of which are his wife, Diane Harwood, and his four children from a prior marriage, Jeremy Harwood, Jason Harwood, Casey Harwood, and also the defendant, Carrie Dwayne Harwood. In April of 2014, the beneficiaries executed a family settlement agreement, which stated that the beneficiaries agreed that upon the sale of decedent's real property located at 2880 63rd Street, Port Arthur, Texas, the net proceeds of the sale would then be divided into 5 equal shares for distribution to each of the beneficiaries by the defendant as independent executor. On May 6th, the will and counsel were admitted to probate by this court, and defendant was appointed as independent executor of decedent's estate. On September 7th of 2014, Jason Harwood, the beneficiary under decedent's estate and also part of the settlement agreement, he died intestate in Topeka, Kansas, and was survived by his wife, the plaintiff, Miss Lori Harwood, along with his 2 minor sons, Lawson and Tyler Harwood. In March 13th, 2015, the real property was sold for $62,110.67 by the defendant in his capacity as independent executor. Despite the sale, defendant has failed to distribute Miss Harwood or children their share of the proceeds.
I remember everything now. I had read it all at one time, and now it's come back to me.
Okay.
The only thing I noticed, sir, is that I do not have an order on the summary judgment. So could you get me an order?
Sure, that's something I've got it all ready to go, but we just haven't sent it over to you yet.
All right. If you'll get it to me, we'll take care of it and let the court know if you need anything else, sir.
Perfect. We appreciate it.
All right.
Thank you.
Y'all have a great week, and let us know if you have any questions or any needs. Thank you.
We will.